Now, I would like to ask Dr. Garayová with the topic cohabitation in the Slovak Republic, myth or reality. It was added to a program, so you have a word, please. Thank you.
Oh, okay. Thank you so much. I didn't actually expect to speak today because I thought that it wasn't possible to actively participate. So I think my contribution today will be quite short and to the point. So yeah, thank you so much for allowing me to be here. It was really interesting to listen to different perspectives of cohabitation. And I really wanted to submit a contribution regarding cohabitation in Slovakia because I think it's a very interesting topic since Slovakia belongs to one of those countries that does not officially recognize cohabitation. So you might be wondering, why am I choosing this topic then on a conference about cohabitation? And the thing is that while we do not have it in our legal system in Slovakia, neither the Civil Code nor the Family Act define or protect the cohabitation itself. There are several legal claims that arise from cohabitation. There are throughout different legal acts within our legal system. So the reason behind this is, I think, first of all, historical and also ideological. Slovak family law, in its essence, is very conservative. So it has a lot of very traditional traits. First of all, I have to, of course, mention that Slovak family law and Czech family law share a lot of their past together, a lot of a common past. So that is undeniable. And basically, the distinction started to happen, after the Velvet Revolution. And this is where we see how Slovak family law evolves and becomes a little bit more traditional in some sense and kind of omits the institute of cohabitation in its entirety. So basically, what happened in Slovak family law is the way Slovak family law is it is not part of our civil code currently. However, we are preparing a recodification of the civil code, and in the future, family law should be in the realm of the civil code. Currently, it is regulated by a separate act, the Family Act from 2005. Now, the Family Act of 2005 in Slovakia was something that was not necessarily anticipated or expected to happen. Originally, the previous regulation, which was the Family Act of 1963, the something that could withstand the test of time in the 21st century. A lot of social changes have happened, a lot of changes in the moral perception of things have happened, and basically the original intent was to just change and adapt the 1963 Act to the 21st century. But when they started working on this legislation, they realized that the changes are more than what really they expected to be needed. So in the end, the legislator decided in 2005 that a brand new Family Act was needed. So this happened in 2005, and this is the Family Act from 2005. Now, basically, one of the biggest criticisms of this Family Act, besides its many, many positives, is really that it completely omits the institute of cohabitation in any of its forms. There are no civil unions, there are no registered partnerships, nothing at all, not even a mention of them. So basically, the Family Act from 2005 introduced a lot of very positive changes, but on the other hand, it also kind of gave footing a lot more conservative interpretation of family law in Slovakia. So the legislation from 2005 already reacts to the Convention of the Rights of the Child, as well as it kind of keeps in mind the future recodification of the civil code. So it includes basically this future vision of integrating family law into the civil code. Now, in preparation of this new Family Act, there was a lot of comparison, a lot of comparative legal work, kind of comparing the family law in different countries, Czech Republic, Germany, Hungary, that was kind of worked into the Family Act in Slovakia. Now, based on the explanatory notes of this act, the biggest changes that were needed, that the legislator felt that were needed, were kind of concerning the grounds for invalidity and non-existence of marriage, different circumstances of marriage, the possibility of regulating a child's contact with close persons, and distinguishing between guardianship and wardship institutes. So there were a lot of changes, but the legislator did not feel the need to include cohabitation in the Family Act. So currently in Slovakia in 2021, neither the Civil Code nor the Family Act define, regulate, or protect cohabitation. However, the Institute does have certain legal consequences in our legal system. Different claims arise from cohabitating with someone when it comes to inheritance, when it comes to different other rights, but the Institute itself is kind of a blind spot in Slovak legislation. So it is a very interesting thing, and it is kind of a discrepancy from the reality of everyday life. Currently, there is no exact reliable statistic on how many couples live in an informal cohabitation in Slovakia, but we do have statistics on how many children are born out of wedlock, and we can see a huge rise in the past 32 years. In 1989, the children born out of wedlock were under 10%. Today is close to 40% in Slovakia. So that really shows that cohabitation is a part of everyday reality in Slovakia. It's just the legislation that does not kind of recognize it in a legal perspective. So this is a really interesting fact of Slovak legislation. I also have to mention another thing, and that is that there were some attempts of getting civil unions, registered partnerships worked into Slovak legislation. There were some attempts of getting same-sex cohabitation or partnerships into our legislation, but currently, regardless of the sex of the cohabitants, this institute does not exist from a legislative perspective. And I also have to mention kind of a more recent evolution of Slovak family law, because, looking at the other member states of the EU, you would think that we are on the way of changing this in our legal system. But I really kind of have to say that Slovak legislation is interestingly turning a little bit more conservative with the evolution of the different rulings of the European Court of Human Rights and different kind of ideologies in the EU. The Slovak kind of legislation is turning a little bit more conservative. So it was actually a decision of the European Court of Human Rights in the case of X and others versus Austria that kind of was the catalyst to take our legislation to a further traditional step, and that was including in a constitution a sentence that was surprising to many member states, and it was a sentence that had already existed in our family law, and that was that marriage is a unique union between a man and a woman. And basically, this is paragraph 1 of our family law. And in 2014, it became also part of our constitution. So it is elevating this idea of prioritizing marriage to traditional marriage, to any other forms of partnerships, cohabitations, and the rights that arise from these relationships to a constitutional level. So even though you might think that the 21st century means kind of a liberalization of these principles in family law in all of the member states, Slovakia is a little bit of a paradox in this sense. We will see what the recodification of the civil code will bring, if there is going to be the cohabitation is going to exist from a legal perspective. Obviously, it does exist from social standpoint, but currently, as I mentioned, legally, it's not something that we do recognize. So that is all from me for today. I really thank you for your flexibility, and yeah, I was a little bit surprised to have the word, but I do hope that it was interesting to you, and I do hope that you'll read about it a little bit more in a written form. So thank you so much, and thank you, Professor Kralichkova, for inviting me. I really, really appreciate it.